All right, so we're going to talk about being a party to a crime, okay, or when liability transfers from the person who actually committed the offense to someone else, okay? So Chapter 7 talks about, does the law allow us to hold someone responsible for someone else's crimes? And how would this arise? So this arises either through complicity or through what we call vicarious liability. Complicity is when someone is liable for someone else's conduct. And in these cases, the issue here is the role that they play in someone else's crime. So they're a party to that crime. They participate in it some way. So they're either an accomplice or an accessory, okay? If you think about this for a minute, I'm sure you can think about some situations in which somebody might be complicit, right? They would be an accomplice or an accessory. Vicarious liability occurs when there's some sort of relationship between the two parties involved, and that relationship makes one party responsible for the behavior of the other party. So what it does is it transfers the actus reus and mens rea from one person to another. So this could be something that an employee does in the course of their employment. We would transfer that responsibility to the employer, parent, child, etc. Both of these concepts, so this concept of complicity and concept of vicarious liability, allow us to hold someone other than the principal offender, the person committing the actual behavior, responsible. So at common law, if you guys recall, common law is before the law is codified, and common law exists in England and it exists in colonial America. There are 4 parties to crime: principal in the first, principal in the second degree, accessory before, and accessory after the fact. So principal in the first degree is the person who actually committed the crime, whereas the principal in the second degree is the person present when the crime was committed and who helped commit it. An accessory before the fact is a person who was not present when the crime was committed but helped before it was committed. And an accessory after the fact is a person who helped after the crime was committed. These distinctions used to be important because common law didn't allow you to try the accomplice until you had tried the principal in the first degree and they were convicted. And the reason they had this rule in the past is because all felonies were capital offenses. If you recall, a capital offense is an offense where the person is subject to the death penalty. And if you think about it, this makes a lot of sense, right? We don't want to try the person who is an accessory after the fact or a principal in the second degree and potentially sentence them to the death penalty if the person who's the principal in the first degree is not convicted. Today, however, we have 2 parties to the crime, okay? We have accomplices and accessories. Accomplices are participants before and during the crime, and accessories are participants after the crime is committed. Accomplices are prosecuted for the actual crime, okay? So they're participants before and during the commission of a crime. And this is considered, participation during a crime is very serious because the punishment is going to be the same for the accomplice and the principal. Okay, and this is referred to as accomplice liability. Accessory liability prosecutes accessories as a separate offense, and it's a less serious offense. It's usually a misdemeanor. These are charges often known as obstruction of justice. Accomplices are often confused with co-conspirators. Conspiracy is an agreement to commit some other crime. So you could conspire to commit murder, you could conspire to deal in drugs. Okay, and conspiracy basically is the agreement. We use this a lot, the United States uses this a lot to prosecute people for drug offenses. It's much easier to prove conspiracy than it is to prove other charges related to drug offenses. The Pinkerton rule establishes this concept that the crime and the conspiracy are 2 separate offenses. So the Pinkerton brothers conspired to evade taxes. They were found guilty of actually evading taxes, but also of conspiring to evade taxes. So you see that distinction there, right? The conspiracy is the agreement to do so. So we agree to evade taxes, that's one offense, and then we actually avoid the taxes. That's a separate offense. So when we look at this, what is accomplice actus reus, right? The accomplice has to take some positive act to aid in committing the offense. Statutes vary as to how they word this. They use words like aid, abet, assist, counsel, procure. Words can qualify as actus reus if they encourage and approve the commission of a crime. Oh, and guess what? And we got a case here that shouldn't be in our slides. We'll talk about this when we actually meet. Accomplice mens rea. Sometimes it's very clear that someone knowingly helps someone. So if I lease an apartment to someone and I know they're going to use it for prostitution, or I sell somebody a gun and I know they're going to use it to shoot somebody, right? So in these cases, it's very clear that I knowingly help someone. It's not always clear, though, that someone has knowingly helped someone. And again, it looks like I forgot to take this case out. Okay, so participation after the commission of a crime. Someone can also be an accessory after the fact, okay? Remember, at common law, accessories are punished like accomplices, okay? Because accessories after the fact. Today we treat them differently. We consider them to be not as bad as someone who helps commit the crime or who actually commits the crime. And so this is a separate offense. So there isn't a conviction for the underlying offense, right, for whatever the crime was. And this is a misdemeanor. And sometimes, as I mentioned before, we call this obstruction of justice, hindering prosecution. Most accessory after the fact statutes have 4 elements. The accessory personally aided the person, right? And so this personally aiding is what establishes, which is our actus reus, our actual physical voluntary act. The accessory knew the felony was committed, right? So knowingly is our mens rea. Or they hindered the prosecution of someone, and they did that purposefully. And then someone besides the accessory actually committed the felony, right? And that's an attendant circumstance. Vicarious liabilities, when we take the actus reus and the mens rea of one person and we impute it to another party. This generally happens most commonly in business relationships. So if a bartender overserves a customer and the customer then goes out, drives home drunk, and kills somebody in the process, the business can be held responsible for that, not just the bartender. So this can flow from people to corporations, as well as from one individual to another. It can be assigned to parents, could be assigned to the person who actually owns a car. So Sutherland's the first person who really talks about this concept of white-collar crime. You guys remember Sutherland? He is the theorist who came up with differential association theory. But this concept of corporate crime is centuries old. Corporations begin with charters the monarchs granted as a privilege exchanged for money. And so early on, they are government entities. Corporate criminal law flows from the Constitution. It's a part of federal law, so it comes from the Contracts Clause of the Constitution and the Commerce Clause. Historically, we've had this really strong belief in corporations regulating themselves, right? The idea here was that a corporation is going to act in their own best interest. They'll behave because it's in their own best interest. And the marketplace will actually control their behavior. But self-regulation has some problems, right? It depends on people exercising self-restraint, and it also depends on having people who are in your leadership positions who are behaving in an ethical fashion. So we want to think about, can you sue a corporation? Can you hold a corporation criminally liable? And yes, we can. We can do both, right? So under law, a corporation is considered an artificial person, right? And so it can engage in business, it can sign contracts, it means it can be sued, and it can also be held criminally liable. That corporate liability comes through the doctrine of respondeat superior. And again, we're going to skip the case. Individuals are also held vicariously liable for their agents. Employers, for example, as I mentioned before, are liable for what their employees do. State vicarious liability rests on statutes within the state. So unless a state statute specifically imposes that vicarious liability, the courts won't impose it. Not all vicarious liability cases are federal cases. It's just that people in cases that are state cases generally don't attract our attention. Most common vicarious liability cases are an employee committing a crime within the scope of their employment, but without the approval or knowledge of their employers. If their employers were aware of that, that would not be an issue of vicarious liability. That would actually be a corporate crime. So the issue here that comes up in most, the legal issue that comes up the most is how we interpret the statute that imputes vicarious liability on somebody. Right? So how do the courts interpret the actual laws? This is why we have cases in our chapter. Most statutes involve employer-employee relationships, but some statutes also address parents being liable for their children's crimes. So in 1995, Salt Lake City, Utah made it a crime for parents to fail to, quote, supervise and control their children. By 1997, 17 states and cities have adopted similar laws. This isn't a new concept, right? This idea of contributing to the delinquency of a minor is an old offense. Usually, though, it requires the child's behavior to be done at the direction or the consent of the parents. So allowing a child to violate a curfew is you contributing to their delinquency. And we've got some cases here, again, that I'm going to try to save for when we have discussion in class. But it's interesting to look at these because we have a couple cases, you know, one that deals with a father and whether or not he's properly supervising his son who's committing burglaries. And then there's another case that deals with, I think, violating a snowmobile law. So this idea of holding parents responsible comes from this vicarious liability concept. These cases and these laws are pretty rare. Generally, we don't like to hold parents responsible for their children's behavior. Failure to exercise control laws are not vicarious liability laws. They're based upon the parent's behavior, right? So the parent failing to properly supervise their child. And contributing to the delinquency of a minor is also not vicarious liability. That's also based on the parent's behavior, right? So that is the parent allowing the child to do something or directing them to do something. So hopefully this has been a good overview of these concepts. So when we meet in class and we discuss the cases, you guys have enough background information in order to discuss them.